So someone reached out to me recently and asked, what's the difference between obstructing justice and hindering apprehension? Well, in this video, I'm about to break down the differences between the two laws in the state of New Jersey. Hi, my name is Daniel M. Rosenberg. I'm a criminal defense attorney and the founding partner of Rosenberg Parent Associates. So obstruction really has to do most times with physical interference. So the statute specifically pertains to when someone obstructs, impairs, or prevents the administration of a law or governmental function by means of flight, intimidation, force, violence, or other physical interference or obstacle by means of any independently unlawful act. So other than physical interference or running away, your conduct can only be obstruction if that conduct is in and of itself an unlawful act. So by way of example, if you entice someone else to withhold testimony in an investigation, that's witness intimidation and obstruction of justice. Now, you're asked to provide information during a motor vehicle stop. You refuse to answer that question. You're told to take your hands out of your pockets while you're receiving a ticket. None of that is obstruction of justice. So outside of an independently unlawful act, if you run from police, that's obstruction. If you jump in the way of police, that's obstruction. On the other hand, if you're asked to get into an illegally parked car and move it, that is not obstruction of justice. If you're asked to take your hands out of your pockets while you're being issued a motor vehicle summons, that is not obstruction of justice. Now, let's switch gears and talk about hindering apprehension. Now, hindering apprehension is broken into two sections. One is hindering the detention, apprehension, investigation, prosecution, conviction, or punishment of another. And the second part of the statute pertains to hindering your own apprehension, detention, investigation, and so on. Hindering apprehension can include concealing or hiding someone else in your home, hiding yourself in your home, destroying evidence, providing cash or money or resources to someone who's trying to flee. So the most common charge we see of hindering apprehension is providing false information to law enforcement. That's typically providing a false name. And whether or not that is a fourth-degree charge, a felony, or a disorderly persons level offense, a misdemeanor, really depends on what you're trying to hinder your apprehension from. If you're hindering your apprehension from a crime or a felony, then it's a fourth-degree crime. If you're hindering a disorderly persons level offense or a non-felony, it's a misdemeanor charge. So if you're stopped and asked to provide information to law enforcement, you do not have to provide that information to law enforcement. But if you provide information and it is false, you're subject to criminal charges. So these are the main differences between hindering apprehension and obstruction of justice. If you or someone you know has any specific questions or concerns about these charges or are dealing with this sort of situation, please contact our office. We're happy to help in any way we can. We are criminal trial attorneys. We have your back. That's what we do.